The second benefit, as I said, and I think this is probably an even larger benefit, although it's not the reason that these are normally marketed, relates to access to the assets in the event of a disability. And when I say a disability, I don't mean you're in a wheelchair. I mean you're not able to handle your own financial affairs. You're mentally incompetent. The most common scenario is, some, Alzheimer's or some sort of dementia for an elderly client, but it happens to younger clients too. So let's get an example. Husband and wife, they have a house. Okay, it's probably their largest asset because they're an older client in this case, and they've paid off their mortgage. And so they've got a tremendous amount of equity. They've got some other assets, but that's clearly their largest asset. And husband gets disabled and needs to be moved to a facility. Now the wife no longer wants to, this is a single family home, she doesn't want to deal with all the yard work or any of that stuff anymore. She wants to sell and move to maybe an assisted living facility or an apartment, and she wants to use equity in the house to help pay some of these bills. Without any planning at all, can she sell that house? Why not? They're both on the deed, and he's not competent to sign the deed. So what would have to happen? He would have to be declared by the courts a judicial incompetent. Something called a conservatorship would need to be opened up, and someone would be put in charge of his dollars. Every penny he has needs to be reported to the courts. Every penny in gets reported, every penny out gets reported. The courts get say over what you can spend money on. But the point is, it can be very expensive, it can be embarrassing, evasive. You want to avoid that. And that's a probate, that's like a probate for the rest of your life. I mean, it's not something that's just a period of time. It's, and people can live a long time with Alzheimer's. So you want to avoid that conservatorship scenario. So what is the first line of protection you can do to give someone access to your assets?
Power of attorney.
Power of attorney. That's the first level of protection. You have a power of attorney, and basically you're giving someone the authority to sign your name for you. Another thing that you can also do, and we'll talk about a little bit, is have something titled jointly. As you know, if you've got an account with the husband and wife, either one of them can fully access that account, right? Now it doesn't work with real estate, but it does work with a brokerage account. So that's another possible thing to do. But again, that only works while you have a husband and wife. As soon as one of them dies, now it's solely in their name, and you're back to this problem again. And you certainly don't want to put your children on there jointly with you, because God forbid they get divorced or get in a car accident, and now your money's subject to their divorce proceeding or their car accident. You definitely don't want to ever do that. If you see someone has assets titled jointly with someone other than their spouse, that's a big red flag. They need to do planning. Okay, so you get a power of attorney. You give your spouse the authority to sign your name. They sign your name. They sell the house. Great, no problem. Problem is, in Virginia and in Maryland and in many jurisdictions, there's no law that requires anyone to honor a power of attorney. Why would someone not honor a power of attorney? And let's first say, what would happen if it's not honored? You're back at the conservatorship, okay? Because there's nothing else to do. But why would someone not want to honor it? You don't want to get sued. And what are the reasons that come up? Well, if it's too old, did they ever revoke it? If it's too new, were you competent when you signed it? If the person you designate doesn't serve, it's only as good as the person you designate. If it doesn't have the magic language that person wants to see in there, they're not going to want to honor it. If there's any questions with regards to motivations, they're not going to want to honor it. So there's all sorts of issues that do come up. They're used all the time in real estate, and you probably heard about it in those situations. Someone's out of town, and they're closing on a house. Well, that's when we've drafted the power of attorney for this transaction. You know the person's serving, there's no issues with competency or motivations or language. It's going to be used in that situation. But that's not this situation. This is trying to use a general power of attorney. When you get a power of attorney in, what's the first thing you do? Can you just say, all right, no problem, I'll give you access to the account? Probably the first thing you did is you sent it to your legal department, and legal decided whether or not they're going to honor it. So that is, and if it is honored, great, there's not a problem. But they're not honored enough that it is a real concern. So what is a better level of protection? What's better access to those assets? The revocable living trust again. Your assets are in the revocable living trust. You become disabled. Your spouse steps in as a successor trustee. Well, now they are the legal owner of those assets. If you didn't want to give them access to that account, they could go to court and get a court order ordering you to do so. It is an enforceable right. And because it's an enforceable right, you don't have to. And in real estate, it's the same thing. People know. All right, I know it's enforceable. I just need to see proof that the trust says what it says, and I'm done. And so because you have that right, it works much smoother, and you just get access to those assets much easier. So it's a greater level of protection. So that is why people should consider revocable living trusts. Not because of the taxes, not because of children issues, probate and disability. Now, is that for everyone? I just said all these great things. Why would anyone not have a revocable trust? Well, there are some downsides to them. I gave you the upsides. Let's talk about the downsides. Downsides are, one, they're more expensive to set up. Two, you got to move your assets in, which means, you know, their time, your time, and you might need deeds prepared. You got to pay for deeds with real estate. So there can be some real costs. And let's talk about the benefits. You know, the benefits relate to, generally speaking, death. Well, they relate to death and disability. Who's most likely to die or become disabled in the next few years? We're all going to die sometime, but who's most likely to die in the next few years? Is it your 20-year-old clients or your 80-year-old clients? It's the 80-year-old clients. So for someone in that age group, these are no-brainers. You absolutely want to have that in there because the benefits well outweigh the detriments. For the younger clients, normally I'm not recommending these. I'll do them. Like an older client that wants a will, I probably wouldn't just do it. There'd have to be extenuating circumstances or something. I'd send them to another attorney. I feel that strongly about them. But for a younger client, I'm normally saying, you know what, a will is probably all you need. Now, if you want to pay for a trust, it's your money, you'll sleep better at night. Any will you're doing for a 20-year-old is really, generally speaking, just to help them sleep better at night. I mean, they're going to have their will done several times before they actually die, most likely. So if that'll help you sleep better, you had a sibling that died young, and so you feel your mortality, then great, I'll still do one for you. Or you're going to Iraq, Afghanistan, you're in a dangerous job, you're one of these fishermen in the world's most dangerous jobs. Something like that, you might want to consider a revocable trust, because now your odds of death are a little higher. So I have had those clients, and in that situation I probably would recommend a trust. So that is, I would say, how you determine these things. Now, 20-year-olds versus 80-year-olds is easy. Where do you draw the line on those things? I typically would switch my clients over from wills to trusts around age 60. That's when I switch them over. If you're in your 50s, your wills are still good enough for you. If I'm doing you from scratch, and so I'm not doing, doing a whole set of new documents, you've got existing documents, most of the time I leave it up to the client, obviously, in this situation. I wouldn't say, no, I'm not going to do a will for someone in their 50s. But what I tell them is, I'll probably switch you over at your 60s. So I find that anyone in their 50s and older tend to want their trust. Anyone in the 49 and under tend to go the will route. So that's just from my experience.